It is very, very surprising. I've been practicing criminal law for decades. I've tried many, many criminal trials and watched many others, and I've never seen testimony go on this long without the jury present. I think the reason the judge did it is actually something that you guys talked about a minute ago, which is SBF constantly talking about lawyers. So in criminal law, there is something called an advice of counsel defense. It's a very specific thing in the law. And you have to give notice beforehand, before the trial starts, to the government, to the prosecutors, and say that you are asserting it. And then you actually have to waive attorney-client privilege between yourself and the attorney. And what you have to prove in order to make out that defense is you have to make it clear and demonstrate that you have let those lawyers know about all the relevant facts and that they approved of or authorized all of the activity that you're charged with. As you can imagine, it is very rare for defendants to actually be able to, have testimony from lawyers that are going to establish that. And so they try to get around that by having what I'll call a quasi-advice of counsel defense. And that's really what SBF is trying to do here. He's basically saying, yeah, there was a bunch of lawyers running around and they were around on the scenes and things like that. So I presume that they were taking care of this. I presume that they were on top of it and they were making sure it was legal. That's not an advice of counsel defense. And I think what the judge is trying to understand here is there enough here that goes to his state of mind, which is relevant, which is, something that would actually be helpful to the jury? Or is SBF and his team, are they really just trying to confuse the jury and essentially try to confuse the issues? That's what I think the judge is trying to understand.
So